Hello, I'm Mike. I'm the host of the Counting to Five Supreme Court podcast. This is our first live stream, YouTube live stream. So thank you for joining me. The Counting to Five podcast, my goal is to cover the court in a way that's accessible to both lawyers and non-lawyers without sacrificing legal accuracy. On today's live stream, we're going to do a preview. Apologize for that. I had an audio setup issue. We're going to take a look at some of the cases that the court is going to be hearing next week. Next week is the first week of the new Supreme Court term. And then we're also going to talk about a few of the most anticipated cases that will be coming up later in the term. And at the end, there's going to be time for some question and answer from the viewers. If you're watching this live, you can submit your questions via the YouTube live chat. And if you have questions about the cases that I'm discussing, I'll try to answer some of those as we go along. But as I said, I'll also try to leave some time at the end for any questions just about the court or about the Supreme Court term more generally. I expect this to run for about an hour. And so without further ado, let's get started. First, I'm going to talk just a little bit about the term generally. So the Supreme Court term, by federal statute each year, the term officially starts on the first Monday in October. And that is typically when the court holds its first oral arguments of the term, and that's what's happening this year. In reality, the court's business for the new year kind of really started a week earlier. This Monday just passed. That's when the justices had their first conference after their summer recess. The court takes a break for the summer. They finish up their business at the end of June and basically take July, August, and most of September off. And they reconvene at the court a week before the start of the new October term. And they have what's known as the long conference. The long conference is when they consider all of the petitions for the Supreme Court's review that have piled up over the summer. So just to step back a bit and explain how the Supreme Court conducts its business, almost all of the cases the Supreme Court hears are discretionary, meaning the court doesn't have to take them. They can pick and choose and take those cases that they want to take. The court, in recent years, the court takes roughly 1% of the petitions they receive. They choose to actually hear, and unlike the Supreme Court, the lower courts that these cases are federal courts of appeal, and the Supreme Courts are highest courts of the various states. Those courts don't take the same kind of summer break. They run year-round. So all year round, there are decisions being issued by those lower courts, and losing parties who want to take their case up to the Supreme Court have a limited period of time to petition the Supreme Court. So those petitions roll into the court year-round from the various lower courts. During the term, while the court is sitting, so between October and the end of June, the justices periodically meet about 3 times a month to discuss petitions that have come in, and they vote internally on which ones to take and which ones to pass on. And these cases that they pick get slotted into their upcoming document or docket for oral arguments. And it's kind of a rolling process. So as they completed last term at the end of June, they had a total of 28 cases that they had granted for the following term, cases they had already agreed to hear, but which did not make it onto the calendar for the previous term. And those cases, the cases the court has already granted at the end of June typically make up its fall oral argument calendar for the following term. That's October, November, December. And actually, just to step back again, let me talk a little about the court's oral arguments. the court hears oral arguments during its term each month from October through April. And each month the court sits for 2 weeks for 3 days a week and likes to hear 2 cases a day each day that it's sitting. So, if you do the math, that's in a typical month where they're sitting for 6 days over 2 weeks, 2 cases a day, about 12 cases a month would be a pretty full calendar for them. Now, they can squeeze in extra cases, do 3 cases a day if they want to, and they do that on occasion. And when they have a light docket, when they just haven't granted enough cases to really fill the calendar up, then they will have days where they only hear 1 argument. And that in recent years has been fairly common. That happens quite a bit, and that has happened. There are some 1 argument days coming up later this term. Their last oral argument session is in April, and then the remaining time between then and the end of June is just when they're trying to finish up all of the opinions on the cases that have been heard since the beginning of the term. And those opinions, as cases get argued, the justices write their opinions, and when the opinions are finished, they get issued just as they're ready throughout the term. But there's always a big crunch at the end in June when the court is rushing to get all of its unfinished opinions done and issued so that they can break for the summer. So as I mentioned, they had 28 cases granted at the end of June, and that those would typically go into their fall calendar, October, November, December. They reconvene at the end of September. So this past Monday, they reconvened and had their conference, the long conference, where they consider petitions that have built up over the summer. Now, they receive a lot of petitions. As I mentioned, they accept only about 1% of the petitions they receive. In recent years, they've received somewhere in the ballpark of 6,000 to 8,000 petitions a year, and they accept somewhere in the range. Has been low in recent years, but 65 to 75 cases, give or take. So after the summer, their long conference, there may be as many as 2,000 petitions or so that they're passing judgment on, and some small number typically get granted each year. Now, they had their conference on Monday. On Thursday, that's yesterday, they released their grants coming out of that conference. They granted review in 11 cases, so that's an additional 11 cases. However, 3 of those cases are actually consolidated for argument. That means they all raise the same legal issue, and for all intents and purposes, you can treat them as a single case at the Supreme Court. So really, they've added 9 new cases for argument. Those cases will probably be on their January calendar. The court's calendar gets released gradually a month at a time. So far this year, they've released the October calendar, which had 10 cases out of the 28 they had issued previously. Now, one of those cases has actually dropped off the calendar. That's the travel ban litigation, which I'll discuss a little more later. So there's actually 9 currently on that calendar. They've released the November calendar, which has an additional 8 cases, and that leaves 10 cases left over for the December calendar, which, those 10 cases may or may not end up on the December calendar. There's various reasons. Some things may be pushed back just due to briefing schedules or things like that, but probably those 10 will end up in December. And then as this term goes on over the next few weeks, as they continue to, the court hears oral arguments and they continue to have their periodic conferences, they'll gradually grant more cases. These cases will be slotted into their calendar, to fill up January, February, March, April. Once the April calendar is basically full, then any additional cases that they're granting after that point will roll over and be heard the following year. That typically happens sometime in January. They will fill up through the April calendar, and anything granted after sometime in January will end up rolling over to the next year. But we won't know until sometime after that because there's a delay before the calendars come out. So it won't be until the April calendar is issued, possibly in February sometime, that we'll know which cases will actually be rolling over to the following term. So that's a basic sense of where we are. So 28 cases at the start of the term, another 9 cases granted after the long conference. The court is still a little light. This is shaping up to be a light term so far. but it remains to be seen, whether they'll step up the pace and try and issue more grants to kind of beef up their caseload as they go along. No way to really know at this point. So that's the shape of the term. Let me move on to start talking about some of the specific cases. Now, last term, the general consensus among commentators and court watchers was that last term was a pretty dull year. It was not one of the more exciting Supreme Court terms. There weren't really any blockbuster cases. There were a few cases that got a lot of attention. There was the Trinity Lutheran Church case, which was about state funding going to a religious daycare facility operated by a church. And that case got a lot of attention. There were a few others, some interesting criminal justice cases, but overall, it wasn't a term with many really hot button, high salience cases. Now, this term is a different story. I might mention that the most likely reason for that is that last term, the court was still short-staffed. They only had 8 justices for most of the term following the death the previous term of Justice Scalia. And an 8-justice court always leaves the possibility of a 4-4 split decision, which leaves the court unable to issue any definitive opinion or resolution of the case. So the speculation is that the court was trying to avoid highly divisive cases where there was a possibility of the court splitting 4-4. When that does happen and they split 4-4, it's kind of a big waste of everyone's time and money. That's the litigants and the lawyers that are arguing the case, and the court's time in reviewing all of the briefing and that kind of thing. So they try and avoid that if possible. So speculation is that part of the reason for the kind of unexciting term last year was that the court was deliberately avoiding some of the more hot button cases. But as of the end of last term, Justice Neil Gorsuch was seated on the court. That was in early April. He sat with the court for the court's last oral argument sitting of the year, the April sitting. And now as the court moves on to this new term, they're fully staffed back up to 9 members, and there are a number of kind of highly anticipated cases on the docket, and there may be more kind of waiting in the wings, other cases in the lower courts that seem like they may make an appearance at the court later this term, possibly. We'll just have to wait and see on that. So I'm going to move on. I'm going to very quickly talk about the cases that the court's going to be hearing next week. So the court has 3 argument days, Monday, Tuesday, Wednesday. It's hearing 2 cases a day. And so I'll just run through those 6 cases very quickly. If anyone who's watching has questions or wants to hear more about any of the specific cases I'm discussing, just please leave a comment in the live chat. And I can go into more detail. I'm just going to writing into the live chat right now. Invitation to please send your questions, and I'll do what I can to respond to them. So let's move on to the cases. So the first case the court's going to be hearing, this is on Monday, this coming Monday. It's actually 3 cases that were consolidated for argument, so 3 cases raising the same legal issue. The 3 cases are Epic Systems v. Lewis, Ernst & Young v. Morris, and NLRB, that's the National Labor Relations Board, v. Murphy Oil USA. And these 3 cases are about the enforcement of arbitration clauses in employment agreements. So arbitration provisions, they have become, an arbitration provision is, an arbitration agreement is an agreement that if a dispute arises in a particular context, you'll resolve that dispute, you agree to resolve that dispute before a private arbitrator rather than in the court system. So you're giving up your right to go to court and saying, if under this contract or under this relationship, some issue arises, legal issue arises, we'll take it to a private arbitrator. And the general idea behind this is that private arbitration can, in theory at least, can be faster and cheaper than the court systems. It gives up some of the procedural complexity and some of the protections of the court system in exchange for a streamlined, faster system. In some contexts, the arbitrators can be experts in particular subject matter areas, so they have they're not just a generalist judge like most of the judges in the court systems that hear all types of cases. They could be an expert in a particular subject matter. And so an arbitration agreement, so an arbitration provision might be included in a contract to force the parties, if a dispute arises, to go to arbitration. The issue here is that in recent years, arbitration provisions, which originally were more often in business-to-business contexts, but they have become much more common in contracts between businesses and individuals. This is things like cell phone contracts, where there's frequently a arbitration provision saying if you have a dispute, a legal dispute with your cell phone provider, you need to go to an arbitrator, not the courts. But also they've become more common in certain employment agreements. So an employee may be told that any legal dispute you have with this employer must be resolved through a private arbitrator. The second important piece to this is that these arbitration provisions often include what's known as a class waiver or class action waiver. And what they say is, if you want to bring, you have to bring this in arbitration, not in the courts, and only individual arbitration, meaning one single person at a time. You can't have a class action or class-wide arbitration where you say all employees of this class or this category bring this claim together against the company. And what the issue in this case is there's a federal statute called the Federal Arbitration Act, and that's been interpreted a number of times by the Supreme Court, and the court has held pretty broadly that the Federal Arbitration Act says that arbitration provisions must be enforced by the court, and there's very limited exceptions for when a court is allowed to ignore a arbitration provision. But the new twist in this case is that the National Labor Relations Board, which is the federal agency that's responsible for employment and labor-related matters, they have interpreted the National Labor Relations Act, which is the primary federal statute dealing with collective bargaining, unionization, things like that. It has a protection for employees that a company can't interfere with employees engaging in concerted activities for mutual aid. And the NLRB has said that class-wide litigation or class-wide arbitration is an example of concerted activity for mutual aid, and that therefore this type of class action waiver is unenforceable. It's illegal under federal law and unenforceable. So the question that's before the Supreme Court right now is, it's been kind of framed as a conflict between the Federal Arbitration Act, which says arbitration provisions must be enforced, and the National Labor Relations Act, which has been interpreted to say that this type of waiver provision, which is included in a arbitration provision, cannot be enforced. And so that's the basic idea of those cases. Those are very closely watched by the class action bar and also corporate labor and employment attorneys, because it has a huge impact on whether these any lawsuits about, for example, wage and hours lawsuits about minimum wage or overtime disputes, things like that, whether they can be brought as class actions, which is the much more economical way for plaintiffs and the attorneys representing them to bring those cases. So the next case, let me move on to the next case that'll be heard on Monday, is called Sessions v. DiMaia. And this is an immigration case. Now, interestingly, this is one of two cases that were actually argued last term. There's this case and another case that's called Jennings v. Rodriguez that I'm going to talk about in a minute. These both immigration cases, these are two cases that were argued last term, but the court was unable to issue a decision on them. Basically, the court was divided 4-4. And as a result, because they had a new justice added at the end of the term, they ordered these cases re-argued the following term, this term. So now they're going to be argued again before a 9-justice court, where presumably they'll be able to come to a decision on the case. But this first case, Sessions v. DiMaia, the Sessions v. DiMaia is a case about a provision of immigration law which makes people deportable for if they have been convicted of an aggravated felony. And the definition of aggravated felony has kind of a catch-all provision that includes any felony that, quote, by its nature involves a substantial risk that physical force against the person or property of another may be used in the course of committing the offense. Now, the reason that there are these types of catch-all provisions in federal law is that the vast majority of criminal law, the vast majority of criminal convictions in this country are under state law. Most crimes are state law crimes. Most people that are convicted are in state court under state law. But the federal government, in a number of contexts, wants to place have federal consequences rest on state court convictions. So immigration is one example. They may want certain felons to be ineligible to come into the country or to be deportable, but they also may, another context is federal felon in possession laws, which prevent certain felons from possessing firearms or create especially harsh penalties for convicted felons who are caught, possessing firearms or who use firearms in the commission of another crime. And those felon in possession laws also often piggyback on state law convictions. So the problem there is that every state's criminal law is different, and they often differ in quite substantial ways. Specific crimes are defined in different ways. They have different elements that need to be proved, which may vary quite a bit from state to state. They're named different ways. When crimes have various degrees, first degree, second degree, third degree, whatever crime, those degrees are often completely different from one state to another. So in order for the federal government to piggyback on top of state crimes, it needs to define them in fairly general terms. So where this comes to Sessions v. DiMaia is a few years ago, there was a Supreme Court case called Johnson v. United States. And that was a case under the Armed Career Criminal Act, which is a statute that has enhanced criminal penalties for certain violent felons or people convicted of a violent felony who possess a firearm. And that the Armed Career Criminal Act also has a catch-all provision that's included felonies that involve conduct that presents a serious potential risk of physical injury to another. And the Supreme Court in that case, after they'd had several cases interpreting this catch-all provision and had kind of gone various ways with not a lot of clear rhyme or reason of why one case falls in or out of this definition, the court finally decided that this clause was unconstitutionally vague. It was too vague for anyone to know what it did or did not apply to, and the court basically threw that clause out, that catch-all provision. So the argument in this case is, just like in that Johnson case, the immigration provision at issue here is unconstitutionally vague. People don't know what counts as an aggravated felony under this catch-all provision, and so it shouldn't be enforceable. So that's the issue that's going on there. Then we have two cases on Tuesday. The first one is called Gill v. Whitford. This case has been getting a lot of attention. It's some people are calling it the biggest election redistricting case that the court has heard in a long time. And this case is about partisan gerrymandering. So that's gerrymandering, meaning kind of creative redrawing of electoral districts for partisan political advantage. So drawing districts in such a way that one political party is advantaged. You can, by doing various things, the two terms are usually packing and cracking. Packing is when you take voters that are, that are likely to vote for the opposing party, and you lump them all together in one district so that there's a overwhelming number in that district, and kind of wastes the extra votes of people who might have been in that district. And then cracking is the opposite, where you take a district that has a majority for a particular political party, and you split those people up between more than one district to remove their majority. And by combination of packing and cracking, and cleverly drawing the district lines to do this, a party can potentially reap a very large electoral advantage. The court has had cases in the past about partisan gerrymandering, but it has never been able to settle on a workable standard for when this is okay and when it's not. The problem is that the use of kind of partisan political goals in drawing election districts is both as old as the country. The earliest partisan gerrymanders go back to the very first congressional election after the Constitution was ratified, and they're ubiquitous. It happens in every redistricting. Politicians who are, party-aligned politicians planning out the districts that are for partisan elections. It'd be hard to expect them to be completely oblivious to or put out of their heads the partisan implications of any line drawing decisions that they make. And because every 10 years when there's a new census, states are required to redraw their districts to keep populations even between districts, this is a recurring problem that just comes up over and over again. So the question in this case is, will the Supreme Court finally say that there is some line that they will draw? They come up with some rule of when partisan gerrymandering, when partisan considerations are too much and just goes beyond the normal political considerations to a too much of an unfair advantage. So that's what the court's going to be thinking about in this case. One important thing about this case is, unlike almost all the other cases on the court's docket, this is a case that they did not choose to take. These election redistricting cases are one of the last remaining vestiges of the court's mandatory appellate jurisdiction. These are cases that they have to take when they come up in the lower courts, and they don't get to pick and choose and leave them alone. So, and I have a question from Shayna in the live chat, and she's asking, right now, the law for gerrymandering is based on the Voting Rights Act and minorities. Yes, it's the not necessarily the Voting Rights Act. It can be a straight 14th Amendment equal protection argument. But yes, racial gerrymandering, race-based district drawing can be there's case law that violates the equal protection clause, and those can be struck down, and that's frequently litigated. That's an issue that arises repeatedly. Last term, the court had two cases that it heard that were about racial gerrymandering, and there's some dispute over the actual application of the standards there, but it's well accepted that that's something that the courts have to police, and they do police. But partisan gerrymandering is another story, and the court has so far been hands off. And interestingly, a lot of times in racial gerrymandering cases, one of the defenses that was used to claims of accusations of racial gerrymandering, one of the accusations, or one of the defenses that's often used, is that no, we weren't trying to deliberately group or move or assign people to districts based on race. We were just doing it on a basis of party affiliation, because especially in certain parts of the country, but to some degree everywhere, there's a fairly strong correlation between race and party affiliation. So in certain areas of the country, black voters are nearly 100% aligned with the Democratic Party. And so in that type of circumstance, the gerrymanders, now this is often directed at Republicans who more often on the current the current state of control of state houses and governors. The Republicans have complete control of many more states than the Democrats do. But a decade or two ago, the Democrats were often in control, and there they were trying to potentially use African American voters to bulk up Democratic electoral prospects. And now the claim is the Republicans are doing the opposite and trying to dilute the power of African American voters for Republican benefit. And the claim in racial gerrymandering cases is often, no, we weren't targeting them as minorities. We were targeting Democrats who just incidentally happen to be minorities in these areas. And that's a claim, you know, sometimes that it may or may not be a successful defense, but that's a defense that's often made. But it's, you know, you generally assume that, well, as long as we claim it's for, or as long as we, if we can convince the court that it was for partisan reasons rather than racial reasons, then we're in the clear. And this case, Gill v. Whitford, you know, that might change things if the court does decide that there's some meaningful standard that it can apply. Then maybe that changes the calculations, but it remains to be seen what the court will do with that. The second case that's going to be heard on Tuesday is Jennings v. Rodriguez. I mentioned that's the second of the two immigration cases that were heard last term, came to a 4-4 tie and got bumped for re-argument this term. And that is a term about immigration detention. Right now, immigration detention is for people who are protesting their removal from the country. So someone who's been picked up for deportation, or someone who has tried to enter the country and is being denied entry, but is protesting the denial of their entry. So they may want to challenge in court and say, I am admissible. Those people denied entry at the border, it's mostly, those would be people with refugee claims. People who are being deported, we're usually talking about people who have a criminal conviction that makes them deportable, but maybe challenging that because there's sometimes dispute over whether a particular this is related to the issue in the other case, the Sessions v. DiMaia case that I mentioned before. Sometimes there's question and dispute over whether a particular crime actually is a deportable offense. But someone who's challenging those determinations is placed into immigration detention. And just because the immigration system moves slowly, just like the court systems often move slowly, those people can be kept in immigration detention for a substantial period of time, sometimes years, before a determination is made on whether they will be removed from the country. The lead plaintiff in this case, named Alejandro Rodriguez, was in, he was had some criminal convictions and was picked up to be removed, deported. He challenged that and spent more than 3 years in immigration detention before he was eventually released. I think his I don't know whether his case is still pending right now, but he was eventually released from immigration detention. But he spent more than 3 years there. Others have spent even longer periods of time. And the claim there is it's basically a constitutional claim that saying people are being deprived of their rights, and they're arguing for periodic bail hearings so that people in immigration detention would not that they would automatically be allowed to be released from immigration detention, but they would be entitled to periodic hearings where they could contest their continued detention and argue that they're not a flight risk or the other considerations, and be allowed out on bail. So the court will be hearing that one again, and again that one the court was divided last term 4-4. So this will presumably be another close case. Probably another 5-4 case. So next, let's move on to Wednesday. The first case on Wednesday, this is a very odd case. It just has some very strange facts. The case is called District of Columbia v. Wesby. The facts here are there was a loud party. This is in the District of Columbia. There was a loud party in a vacant house. The police were called due to a noise complaint by neighbors who said that they believed the house was vacant. And the police entered and found 21 people in various places in the house. Some of them had scattered and hid themselves when the police showed up, but the police rounded them up, asked the people why they were there, why they were in the house, and several of the partygoers told the police that someone named Peaches had invited them to come to this party. Now, Peaches wasn't there at the house, but the partygoers were able to call Peaches on a phone and put Peaches on the line with the police. The police talked to this again, Peaches. She was not willing to come and show up at the house, but she told the police that yes, she did invite the people to a party there, but then after further conversation, admitted that she had no permission to be in the house. The police then went and arrested all of the partygoers for trespassing, and brought them down to the station. Now, their charges were later dropped. They dropped the charges, and you'd think that's that case is over, but not so fast, or we wouldn't be here in the Supreme Court. 16 of the 21 arrested partygoers brought a federal civil rights lawsuit against the police officers and the District of Columbia, arguing that it was a wrongful arrest. It's a Fourth Amendment claim saying it was a unconstitutional seizure when they were arrested in this house. And their argument basically goes that a trespassing conviction, one of the things that has to be proved for criminal trespassing is the criminal intent. The person has to have known that they were not authorized to be on the property that they were allegedly trespassing on. And the partygoers basically argue, we said we were invited by Peaches. The police talked to Peaches, who confirmed that she didn't invite us. If we believed that we had permission to be there, then there can be no intent, criminal intent, and we can't be guilty of the criminal offense. So they said, given what the officers knew at the time, they had no evidence, hard evidence otherwise, that the people that any of the partygoers knew they weren't supposed to be there, and so they say this was just an illegal arrest. The district court, there was a trial, and the plaintiffs, they won, and they got a $680,000 verdict against the police, and with attorney's fees added on to that, it was over $1 million in the verdict that these plaintiffs received, and that award was affirmed by the DC Circuit Court of Appeals. So now the police officers have brought this up to the Supreme Court, and they argue that basically this should be judged not on the basis of just these limited facts about what they told the police about their permission and what Peaches told them on the phone, but the totality of the circumstances, and the police could look to suspicious behavior by the guests, running and scattering, and other things like that, and that would allow the police to have discredited the partygoers' claims of their belief that they were authorized to be there, and make the arrest legitimate. So that's kind of their side of it. And there's a second issue, which is something called qualified immunity. And qualified immunity that comes up in claims, civil rights claims against government officials, if the law wasn't clear, if it wasn't clearly established law at the time that a government official took a allegedly unconstitutional action, then they can't be held personally liable, monetarily liable for damages, if it wasn't clear. It's called qualified immunity, and the court has been very willing to find qualified immunity in many circumstances and basically shield government officials from liability unless it was crystal clear that what they were doing was something that was unconstitutional. But the lower courts found no qualified immunity, so that's another issue that's live at the Supreme Court. It's an odd case because it doesn't seem like the kind of case that the court would normally take. This case, it seems to turn on these very, very specific facts about what was going on in this this vacant house when the police came and found this party going on, and it doesn't seem like the kind of case that lends itself to any kind of broad rulings that would be applicable to lots of cases all over the country, and that's usually the type of case that the court likes to decide. So it's a little bit of an oddity that they even took this case in the first place. So that's an interesting one. And then the final case of next week is called Class v. United States. And this is a case, it's an interesting case. It's actually about the effect of a guilty plea in a criminal case on the right to appeal. So the petitioner in this case is named Rodney Class. He was arrested of possession of guns on Capitol grounds in DC. Now, what had happened is he had parked his car in a parking lot on a public street in DC. Now, it turns out that that parking lot was a permit-only lot that he shouldn't have been parking in, but that's kind of beside the main point. He parked in that permit-only lot, left his car, Police found his car illegally parked in this lot. They were suspicious of the car, searched it, and found a number of weapons, guns and knives, other weapons that were stored in the car. When Class returned to his car, he was arrested for possession of guns, possession of firearms on Capitol grounds. It turns out that this parking lot was officially within the Capitol grounds, and that made it a federal offense to have weapons on the premises. He was charged. He represented himself in the district court, the lower court, and he raised defenses under the Constitution, arguing that both that his possession of firearms in his car was protected by the Second Amendment, and also that he was denied due process because there wasn't adequate notice. There was no way of him knowing, it wasn't posted, that the lot he parked in was part of the Capitol grounds. The trial judge denied these claims, and after the claims were denied, or the defenses, these constitutional defenses were denied, he pleaded guilty. Immediately after pleading guilty, he appealed the conviction up to the Court of Appeals, bringing again his constitutional claims, saying that the constitutional defenses were wrongly denied by the trial court. In the Court of Appeals, that he had, by pleading guilty, he had waived his right to challenge the convictions on constitutional grounds. Interestingly, the plea agreement he entered into when he pleaded guilty, it did explicitly waive certain rights. Like, he waived his right to appeal a sentence within a certain range. So if he ended up getting a sentence within a certain range, he had no right to appeal that, and he had agreed to that. But there was no explicit waiver of his right to appeal, and nothing that spoke to constitutional challenges. So he argued he was still able to bring that. The government argues that no, those are foreclosed. When you plead guilty to something, you're implicitly agreeing that there's a constitutionally valid crime that you're pleading guilty to. There are a couple older Supreme Court cases, one called Blackledge and one called Mena from 1974 and 1975, where the court said in certain particular circumstances, one was when someone alleged a vindictive prosecution, and the other one was when someone had a double jeopardy claim, that they were being tried twice for the same crime. In those particular circumstances, the court said, because they go to the question of whether this prosecution could ever have been brought in the first place, then a guilty plea does not prevent someone from appealing that. You can plead guilty and then still appeal on the grounds that it was a vindictive prosecution that should never have been brought. You can plead guilty and then say, I pled guilty, but I couldn't be legitimately convicted of this because of double jeopardy. And the court said that was okay. Here, Class argues this is the same sort of thing. If it was an invalid law that he was convicted under, it was unconstitutional, then he never should have been able to be convicted in the first place. And so he's arguing on the basis of those cases that he should be able to go forward with his appeals. Now, that means even if he wins here, even if he wins at the Supreme Court, all that means is he can go ahead with his constitutional claims. It doesn't mean he's going to win on his Second Amendment claim or his due process claim. He would still have to go ahead with those and win on one of those claims. So this a victory in this would just be an ability to keep litigating and move ahead with his claims. So that brings me to the end of the 6 cases coming up this first week of the new term, and there's some interesting things in there. There's a few cases I'm going to mention. Very quickly, I'll try and run through some of the most high-profile cases that are coming up later in the term. Just a couple of them, just really briefly to kind of put them on the table there, and then I'll leave a few minutes if we have any questions from people at the end. If you have any questions either about any of these cases or just general questions about the court or the term, feel free to throw them now in the live chat comments, and I will take a look at those and try and get to those in a few minutes. But the first case I want to talk about, I mentioned it briefly earlier, is the travel ban litigation. This is the litigation over President Trump's executive orders, one issued in January, a week after inauguration, and the other at the beginning of March. And the March one superseded the earlier one, but the travel ban litigation was an executive order. There were two basic parts at issue in the executive order. One part is referred to generally as the travel ban or the entry ban, and that was a prohibition, a temporary prohibition for 90 days on nationals of 6 particular countries entering the United States. So there was people from 6 countries, and these countries were all in Africa or the Middle East. They were all majority Muslim countries in Africa or the Middle East. And the nationals of those countries for 90 days were unable to enter the country. Initially, the first version of the travel ban applied even to people who already had a valid visa issued prior to the travel ban, but then that was later rolled back. The second class, or the second part of the travel ban, is it's the refugee ban, and that was a 120 day ban on refugees entering the United States, and that was not limited to specific countries but was global. And the stated purpose of these bans was to allow the government time to review all of its policies, to gather information from foreign countries that it was dealing with, and to kind of fully assess the security needs for any such limitations on entry into the United States and formulate a permanent policy going forward. What ended up happening with this case is because the lower courts, this was immediately challenged in numerous districts all over the country. There were several injunctions issued against the government, orders telling the government that it could not enforce the travel ban, that basically put it on hold. There was some, it was appealed to a few different appellate courts who also agreed and kept this on hold. Eventually, it made it up to the Supreme Court, and at the last day of the Supreme Court's last term, it was June 26th, the Supreme Court partially lifted the lower court's injunctions, so partially allowed the travel ban to go into effect for certain classes of immigrants, basically immigrants that didn't already have a pre-existing legitimate connection with the United States or U.S. citizens. And basically, the administration's position was that the 90-day clock didn't start running until that was lifted. That 90-day clock, if you do the math, from June 26th, it ran out this past weekend. Sunday, this past weekend, was the last day of that travel day. Well, on Sunday, as was anticipated, the Trump administration issued a new version of the travel ban by a presidential proclamation. This new version changed it somewhat. They swapped out some of the countries, but also expanded it to 2 countries, 2 non-Muslim countries now, North Korea and Venezuela. And one of the grounds for challenging the previous ban was that it was actually a unconstitutional exclusion on the basis of religion, and it was a violation of the Establishment Clause. And so this kind of changes the groundwork a little bit by adding some other countries into it. But it's now a permanent ban rather than a 90-day ban, but it's supposed to be reviewed every 180 days. What happened was, on Monday this week, after this new ban came out, the court dropped the Trump case from its argument calendar. It was supposed to be argued on the 10th, so next Tuesday, or the Tuesday of the second week of the court's term. The court dropped it from its calendar and ordered the parties to do additional briefing about whether there's still a live case due to the expiration of the previous ban they'd been challenged and due to the new ban with different conditions, different countries applying, things like that. So it remains to be seen whether this will stay on the court's docket in some fashion. A lot of the consensus seems to be that the court is likely to get rid of this case, to declare that this case is moot because the ban that was being challenged is no longer in effect, and that any challenges to the new version of the travel ban will kind of be allowed to go forward in the lower courts first, and then potentially make their way back up to the Supreme Court after the lower court has had a chance to consider and think about these new bans. The Supreme Court often says it's a court of review, not first view. It doesn't like to take the first crack at things. It likes to let things play out in the lower courts first, and then take a look at it afterward, after kind of the arguments have all been played out and ruled on below. So that's a case that probably won't be heard this term, but it's still kind of hanging out there. One more case, another case is called Masterpiece Cake Shop v. Colorado Civil Rights Commission. And this case, this is one of the highest profile cases that's getting a lot of attention, and this involves it's a Colorado cake shop, Masterpiece Cake Shop, and the owner whose name is Jack Phillips, who describes himself as a cake artist. And the facts behind this are a same-sex couple came to his cake shop and tried to order a wedding cake for their upcoming wedding. Phillips refused to sell it to them, telling them that he did not approve of same-sex marriages, and they left. Now, one of the important facts of this case that may or may not end up being relevant to how the court decides it is that there really was very, very little discussion between Phillips and this couple about any details about what exactly he was refusing or what he was offering to do. Now, he has said he was willing to provide, he was willing to serve gay clientele. He was willing to provide them with cakes and custom things for other events or purposes, just not weddings. And he was perfectly willing for them to buy off-the-rack pastries, but just not a wedding cake, which are all custom made in his shop. And the argument here, he has made a religious free expression argument. That is actually viewed as a fairly weak claim because of some prior case law that makes claims of that type when there's a generally applicable law that isn't specifically targeting a religion. That's hard to win. But the stronger case he has is a First Amendment compelled speech claim. He's arguing that basically the government is forcing him to express express beliefs that things that he does not believe in. They're making him speak through his preparation of a cake. Now, it may sound ridiculous at first. That this is a cake. It's a pastry. It's not speech. This isn't someone saying you have to say these words or write these swear to some doctrine we want you to say you believe. But the court has long protected under the First Amendment various forms of expressive conduct. You can think, for example, of wearing flags or burning a flag. It's expressive conduct that clearly carries a message. You look at the actual cake that the couple who were denied from Masterpiece Cake Shop, the actual cake that they eventually got for their wedding, which ended up being provided free of charge by another bakery, had a rainbow flag on the cake, which is clearly a political message that's very easily understood by anyone who sees that cake. You could see in some easy cases, easier cases would be if there were actual words written on a cake that express something. You could imagine a wedding cake that had written in icing on the cake, "God bless this union." That would be expressing a political or religious viewpoint, and you might look at that as expression. But what about just a plain wedding cake, just a fancy decorated wedding cake that doesn't have anything overt on it that seems to convey a political message? Is that still protected? That is part of the issue that's coming up here. You can still abstract works, pieces of art, abstract pieces of art that isn't representative can still be protected expression. But is that the type of thing where there's really a compelled speech claim here? The argument on the other side is, look, what he's really objecting to is not the message that a cake conveys, but how the people plan to use the cake, the venue that they're going to serve that cake. And that puts you in a category with things like someone who says that they have an objection to same-sex marriage, so they refuse to rent chairs and tables for a wedding. And that seems more in the context of what traditional anti-discrimination laws have always prohibited. So that makes this case tough, and it's possible that he could his claim could fail on the basis of the lack of any discussion with the patrons about what they actually wanted on the cake. And if they had said, oh, just a plain vanilla wedding cake is all we're asking for, then maybe he doesn't have a claim. Maybe he would have if they wanted something distinctive, that carried some more obvious political message. But whether the court would draw lines in that way is not clear. I'm just going to really quick, I'll touch on a few more cases. I'm not going to go into much detail on these, but one case is called Carpenter v. U.S., and that's a Fourth Amendment challenge to it's whether the Fourth Amendment protects cell phone location data that's held by cell phone providers, whether the government can come in and demand those as business records, or whether there's protection under the Fourth Amendment that would require them to get a warrant and go and have a showing of probable cause before they could get someone's location data from a cell phone provider. There's two consolidated cases that are about New Jersey sports betting. These are kind of odd ones. One's called Christie v. NCAA, and the other's New Jersey Thoroughbred Horsemen's Association v. NCAA. And these involve a federal statute that's called the Professional and Amateur Sports Protection Act. And that statute, it doesn't actually ban sports betting, but it prohibits any states that weren't currently allowing sports betting, which means every place except for Nevada. It prohibited them from authorizing sports betting. Now, at the time, except for Nevada, every state had prohibitions on the books against sports gambling. What happened is New Jersey decided it wanted to allow sports gambling in its casinos. And first, it passed a bill authorizing sports betting. That was challenged in court as violating this law, and the New Jersey backed down. Then they had their second try. What they said is, we're not going to pass a new law authorizing sports gambling. We're just going to repeal our current ban on sports gambling. And the federal government came back again and said, and the NCAA's brought this challenge. They're saying you can't do that. That still violates this. That's effectively authorizing it. And their argument is, no, we're not authorized to implement the federal government's ban. If they want to ban it federally, they can do that. But we don't have to ban it here in New Jersey. We can repeal our own ban. And so that's the basic argument there. So that's an interesting case. It falls under a line of cases called anti-commandeering. So that's, to what extent can the federal government force states to kind of do its bidding and enforce the federal government's policies or regulations. Then I mentioned that yesterday there were some brand new cases granted, 9 cases granted for the term that'll probably be heard maybe in January. There's a couple of those that are looking kind of interesting. One is called Janus v. American Federation of State, Municipal, and County Employees, and that's a challenge to compulsory union dues used for collective bargaining. That's an issue that's been at the court a bunch of times before, and actually the last time they heard this a couple years ago, the court split 4-4 on that. And didn't have a decision. So that's going to be a closely watched case. There's a couple of Fourth Amendment cases about searches of cars that could be interesting. And there's also a case, an interesting separation of powers case about judges on military commissions. And there's an argument that certain judges on the Court of Military Commission Review, which is an appellate court over military commissions, they were ineligible because of their service on a different judicial court, the Court of Air Force Court of Criminal Appeals. Because of their service on those two courts, they were ineligible for that, and that certain convictions, or I got that backwards, the other way around, that their service on the Air Force Court of Criminal Appeals is invalid because of their service on the Court of Military Commission Review. And so there's a challenge to convictions under those judges. So those are some interesting ones coming up later in the term. There's a couple questions in the live chat that I'm just going to talk to quick. If you have anything else, throw your questions out there now, and we'll see what we can cover in the next couple minutes. I have a question here about this is bringing us back to District of Columbia v. Wesby. This says, are you aware if any charges were ever brought against Peaches? Peaches would be the mysterious person who invited the partygoers to the house. As far as I know, I don't believe that the police are aware of the identity of Peaches. She's still described and identified in the court pleadings, all the ones I read at the briefing, just through using this pseudonym Peaches. So I'm not sure they ever found out who Peaches actually is. It's just one of the kind of odd little details about that particular case. And question going back up to this is from Shayna from earlier, and this was when we were talking about the collective bargaining, the class action waiver in arbitration provisions, and asking about, are the implications on this case with the union case. I think this is referring to the case about the union whether unions can collect the agency fees, mandatory fees from non-union members. And I don't think that there's going to be any connection there, because these are being brought as kind of freestanding constitutional claims against the union, and the people that are bringing the claims are non-members of the union. So even if the union itself had arbitration provision that required union members to arbitrate if they had a dispute with the union, the people who are bringing these claims are people who have chosen not to join the union, who are saying, I don't want to be forced to pay money to this union that I don't agree with. And so since they've never joined the union, they wouldn't have any contract with the union. So I don't think that that would have any application, if I understood the question correctly. I'm going to wrap up. I don't see any more questions. If you have any last questions, throw them up there and I'll try and get them in quick. I know there's a lag between the video and when you're seeing it. But I'm just going to wrap up quick. First, anyone who's watching this, if you're not already subscribing to the Counting to 5 audio podcast, please do. You can find it. The podcast is at countingto5.com, but you can also find it on iTunes, on Stitcher, and pretty much whatever your favorite podcast app or service is, you should be able to look it up and find it there. Please subscribe. We have periodic audio podcasts where we discuss various cases before the courts. We have some interviews with attorneys who appear before the court, things like that. And anyone who's watching, whether you're watching now on the live stream or you watch this as an archived recording later, please, I'd love to hear your feedback. This is our first live stream, and we're hoping to do more of these, but it depends on what kind of response we get. You can leave a comment on the YouTube page. You can send an email to mike@countingto5.com. You can also find me on Facebook or Twitter under Counting to 5. And I would love to hear any feedback you have on this or on the audio podcast, any requests or suggestions for future episodes of the audio podcast or for future live streams like this. And with that, I'm going to wrap it up. Thank you. This has been Counting to 5.